Bottom of the theory case counter plan, just as an overview. Ready?
Next, everybody gets to consider the accessibility advantage of speaking for someone and from and higher than less surgery on next, critical independent and from multiple lives, for strict to the efficient use of language and negative flexibility outweighs the enemies to worlds generate the often been around. We should not be able to test the planning for the acid of the and next unconditionality is worse because it allows no and the negative no chance to win. Next, go on to the case. Drop down to the argument where I made the argument that they don't lead to a further explosion. They make the argument here that all they have to do to win their act is that they need all they have to win is that they need to act ethically. They say acting ethically gives them the ballot. That means if we prove that the counter plan acts ethically, then we win. They have no reason why if we win that their plan kills everyone in the world, it is still ethical. Do not allow any new arguments on the 1AR. Next, go on to the counter plan. First, they say permutation. Do both the links to that benefits. We want any risk. Link to our nuclear list, and then you will reject the permutation, and they don't have a shielding argument, don't allow any new arguments. Next, I say state courts. Next, I say state courts are responsible. Our argument results in the exact same policy. And the one I see, there's no reason that we are self responsibility, and that's the states are responsible for the status quo because they were the ones that enacted the parental notification laws in the first place. Remember that the case was Pennsylvania. It had to do with Pennsylvania's constitutional laws, which upheld parental notifications. The states are taking ethical action against their own restrictions. That means we Catholics do not let any do, and our do not allow any new linear extrapolation. They didn't solvency deficits now using their ethics in the 1AR. This would not be new and unpredictable. They do not extend all piece of evidence on the 1AC that would give them this argument. You do not allow any new extrapolations as to why weighing states against the federal government is unethical because there is not a warrant in the 2AC. Next, state has state conflict for enforced with this argument links to the case as well because the states will continue restricting the states won't do anything about it, and we solves this. We say that enforcement is guaranteed. This is durable fiat, and the fiat of court solvency is pretty key on this topic because if we didn't get it, the affirmatives would never be able to win because we could just say things like Congress or Congress would roll back or that Roberts would vote against it right away. We fiat that the state courts would uphold this in their constitution, and if they restricted, then the state courts would get rid of the policy of parental notification. Next, state action would be rolled back, but durable fiat is good. Or we could just say Roberts would overrule their plan, post-plan, and extend our health arguments that says state constitution. The language is better for protecting abortion claims, and their evidence only refers to one state at the most, and they have no reason why this solvency deficit would outweigh the Indian nuclear deal and the uniform. And that's fine. 2NC politics. Extendable evidence India will be brought up from land restriction no has because the bipartisan support extended has an evidence contentious Supreme Court decision like the plan bipartisanship and each side tries to distance themselves from the ruling and blame the other side. And accidentally go out because the bill was based on the blame petition it fails the Democrat will take over and the committees in the majority party the deal will have to be redrawn from scratch. Our efforts in case Democrats are greatly influenced from non-proliferation to allow people to be able to crush the bill if it goes restructured because then the NDA evidence bill is unsettled for use in new relations now. It has been promised too late to take that. The impact of New York Times evidence to strong U.S.-India relations to keep prevent war with Texas and terrorism and additionally nuclear war between India and Pakistan is the biggest and most probable scenario for war that's 5 to 1. What's interesting in the plan is connecting just route to catch fire between the nuclear people and India and Pakistan and same time wars but the rage selling and countries for nuclear battles and nuclear winter front and the entire goal of the United States will enjoy no sanctuary. This populated version is no U.S. for war. We outweigh because the completely conceded scenario of extinction which outweighs on a probability because of that Carter B magnitude leads to the extinction of everyone and see time frame okay. And they say the India deal is passed, but no, it hasn't. It's only passed Senate. It's going to a conference committee, and both the deal won't be completed until this process and the House and a compromise and the India bill is needed. The U.S. established 2006 and what's the different version of the bill is significant majorities in our working together to respond to election. The post not to be for a very the American will be able the United States government and Indian government will support and next India deal passed now. India deal passed now, but it hasn't added into times 2006. Was not noted India reservation for some representation House and Senate bill. Some of these are not here, but the system to Senate bill was very good one beyond the federal government. They say and the next step which will force Democrats to react with our link is time issues, how decisions spark debate in Congress. If this is uniqueness takeout, then our specific uniqueness outweighs in court rulings create congressional partisanship and debate. As Campbell and Stack in 2001, legislative action tools that started from ideological proposal to personal law, repeals towards the validation of federal law, and congressional politics generally. Congress will regularly reviews and challenges it to the Supreme Court, the high judge, non-existent athletic vacuum, and Congress will react to Supreme Court decisions and search partisanship debate that they can't rulings Congress included vital political action, including unilateral official initiative, lobbying and official subject, committed publicity, and progressive organization, process displacing controversial system, electoral land using judge forms, and catalyzing, the discouragement political mobilization around among various political audience. Next, politicians will blame the courts, but our MSK indicates that even if they do blame the courts, they still take some responsibility for their constituents, and this will list a very small amount available time needed to pass through the Indiana land court rulings affected Congress here since 2005. The court being smart to prevent political coverage not in the world, which before the court seems to politicize boundaries, especially on the area of representation prison approved by Congress to highly only court action will not police president in Congress. Prosecutors argue that the court insulated from policy and the equal process which Congress would perceive at least a large release from for a court ruling that received the attention of the public.
Take some